Okay, we are just opening the webinar for attendees. So as you log in, you should see the cover slide for today's webinar on your screen. Hello, thank you for joining us for today's webinar. We are just allowing attendees to join the room. So we will allow a couple of minutes for that to happen. We will try to get started right as scheduled. You should be able to see the cover slide for today's webinar presentation on New York employment discrimination amendments. You should also have access to a chat window. We will use the chat to allow you to ask questions, and we will do our best to answer all of those, mostly at the end of the presentation. I know there's a large number of attendees today, so we're going to allow everyone to join. I'm just saying hello just so you hear something and know that you're in the right place and can make sure that everything is working on your end. I am Scott Horton, today's presenter for this webinar. I will check back in just about 30 seconds, and then we will give everyone a couple more minutes to log in. Welcome again. You should have the cover slide for today's webinar on your screen. You should also have access to a chat window where you can type in questions that you may have. I will go over all of this again right when we get started. We still have a number of people who are logging in. We will get started right as scheduled, but I want to give everyone a chance to get logged in. If you want to test out the chat function, that is how we will be doing the question and answer portion of the presentation. I will mostly be answering the questions at the end of the presentation, but feel free to type them as they come to mind so you don't forget. If there is a question that I happen to see that is particularly relevant to what I'm discussing at the moment, I may address it then. Otherwise, we will answer all questions at the end. I see someone did type a test message into chat, and I have seen that. Again, just about another minute. I think this is our largest audience to date on one of these webinars that we've been doing for the last year and a half or so on a nearly monthly basis. So I'm sure many of you are interested in learning about this topic. I'm sure many of you probably wished you didn't need to learn about this topic as well, but I am happy to be able to share information with you nonetheless. So again, I'm just going to give about 30 more seconds and then I will get started. Okay, good afternoon. We've had a few more just joined since the last time I spoke. I imagine some more will continue to trickle in, but we will go ahead and get started. We have a lot to talk about. This is the webinar on New York employment discrimination amendments. I am Scott Horton, founder and attorney with Horton Law PLLC. Happy to have the opportunity to share information with you all today about some recent legislation that affects all employers throughout the state of New York. You should have the cover slide in front of you and access to a chat window. Just keep in mind whatever you type in chat is not necessarily confidential. There is no attorney-client confidentiality in any communications we have through this webinar. So if there is something you need to keep confidential, especially if I happen to be your attorney, feel free to contact me separately to ask that. But if it's a general question, then type it in as you think of it, and I will answer most questions at the end. As I usually do, I'm going to aim to keep this to about 1 hour. However, there is a lot to discuss, and I expect there will be many questions. I'm happy to stay on as long as there are questions to continue answering them. But for that reason, I will probably not be answering too many questions during the presentation itself. We are talking today about a number of legislative amendments coming out of Albany late in June that occurred at the very end of the legislative session. There's significant activity affecting the workplace, including this topic on employment discrimination, most notably. Here's an overview of the different components of the legislation that we will be going over in this webinar. The human rights law, which is New York's general employment discrimination statute, has been significantly amended, and we will talk about those details. The amendments also include some issues affecting arbitration provisions in employment contracts and non-disclosure or confidentiality agreements related to settlement of discrimination claims. The amendments also affect policies and training generally on employment discrimination, but specifically there are new requirements regarding the New York sexual harassment policy and training mandates that took effect last year. So many of you may know that there is an October 9th, 2019 deadline for every employer in the state to conduct their first annual sexual harassment training. For reasons we're going to discuss, some of that training may need to change, and some of the requirements related to the policies themselves and the training session will change under these new laws. Those first four areas are all legislation that is pending for Governor Cuomo to review, consider, and act on. It is presumed at this point that he will sign that legislation, but until he does, none of it is in effect now. The last topic on our agenda for today relates to pay equity, and these are a couple of amendments that have already been signed off on by the governor last week. So the clock is already ticking for the effective date on those. There's actually one amendment to the human rights law, which has already been signed as well. And I will note that when we discuss it. So throughout the presentation, I'll be explaining what the changes in the law entail. I'll also be noting the effective dates, but for the most part, there will be effective dates based on when the governor signs. So a certain number of days after the governor signs the legislation, it will take effect. So first, the biggest area, and the one that's going to probably have the broadest impact on employers and employees for that matter, are a series of amendments to the New York human rights law. Now, here are the categories that are protected from employment discrimination under the human rights law: age, race, creed, color, national origin, sexual orientation. The most recent addition is gender identity or expression that took effect earlier this year. Military status, sex, disability, predisposing genetic characteristics, familial status, marital status, and domestic violence victim status. There are a couple other specific protections under the human rights law, but these are the ones that are most broadly and generally protected from employment discrimination, including harassment, and the ones that the amendments affect. So none of these have actually changed under this most recent legislation. Many of these have been around for decades. Some are more recent. And like I said, the gender identity or expression specifically came into the statute earlier this year. But the one of these categories that has been addressed by the new amendments is race. And this amendment is already in effect because Governor Cuomo signed it last week and there was an immediate effective date. So now race is defined in the employment discrimination provisions to include traits historically associated with race, which is further described to include but not be limited to hair texture and protective hairstyles. So we'll talk about in a second. The law seems to most specifically be referring to hairstyle protections. This relates to laws that were passed in New York City earlier this year. But I do note the first provision that race now includes traits historically associated with race. So it's not necessarily limited to hairstyle. It's also at least arguable at this point that someone who has a hairstyle that is associated with race but is not him or herself actually a member of that race, for lack of a better way of putting it, would still have protections. So I think the courts will have to give us more guidance on that issue going forward. Focusing on the hairstyle discrimination, protective hairstyles is further defined, although only by illustration, not exhaustively. So protective hairstyles are defined to include but not be limited to such hairstyles as braids, locks, and twists. So that again is an amendment that is in effect now. One could make a reasonable argument that these characteristics were already protected in a sense by basically being proxies or demonstrations of race, for example, to the extent that race discrimination has long been prohibited. But again, in case there's any ambiguity, or arguably in case someone not of a certain race nonetheless chooses to have a hairstyle reflective of traditional, I'm going to say racial stereotype, but that's not exactly what I mean, but I think you understand. Then there might now be protection where there wasn't before. All right, some of the more sweeping amendments to the human rights law are again in that package of legislation that the governor has not yet acted on, though it's expected that he will sign it. From my perspective, and sort of looking at it from the employer standpoint and what's reasonable for business in the state standpoint, I think there are many good reasons for the governor to consider not signing the legislation, but he has generally supported it, and I think it would be politically difficult for him not to sign it at this point. It is possible that he is considering some timing considerations, as perhaps we'll discuss as we go along. So the most fundamental issue, I think, is who is covered by the human rights law. And there are expansions in this legislation for both the number and type of covered employers as well as covered workers. Currently, all employers of any size are covered for sexual harassment claims as a result of previous but recent amendments. For all other categories, all of the other characteristics on that list that I showed, currently employers are only prohibited from discrimination by the human rights law if they have 4 or more employees. The amendment that's pending would extend coverage to all of the employment discrimination protections to all employers of any size for all protected categories. That amendment will take effect 180 days or approximately 6 months after the governor signs the bill. With respect to the workers, currently there is sexual harassment protection for even non-employees in a workplace, including contractors, subcontractors, vendors, and consultants. A particular entity is only liable to employment discrimination. Again, they're employees for all other protected categories. This legislation would extend the protections to non-employees in the workplace for all protected categories. In other words, if you have a company and you have employees and you have other people coming into your workplace, be they independent contractors or vendors who happen to come into the workplace, and they suffer some form of harassment in the workplace, then they could have a claim against your company even though they are not your employees. That's currently only the case for sexual harassment, but under these laws would be the case for all forms of protected characteristics. There is a slightly higher burden of proof regarding non-employees. They would have to show, for example, that they had some control over the circumstances or knowledge of the harassment, where, especially under this legislation, as we're about to discuss, an employee may not have to make the same showing. This particular component of the legislation will take effect 60 days after the governor signs. All right, now the harassment piece here is where we really get into probably the broadest expansion of the human rights law under this recent legislation. Most notably, perhaps, the legislation specifically eliminates the long-standing severe or pervasive standard. So it used to be to make a legal claim of harassment under either the state law or federal laws like Title VII or the Americans with Disabilities Act. Harassment claims required a showing that the behavior was severe or pervasive. So it was possible for a single instance to cross that threshold, but it would have to be rather severe, and lesser forms of harassment would have to continue over some period of time to meet the pervasive standard. Under the amendments, harassment now becomes unlawful when it subjects an individual to inferior terms, conditions, or privileges of employment because of the individual's membership in one or more of these protected categories. So the reference there is to inferior terms, conditions, or privileges. There's commentary and some case law that would refer to this as sort of a less than standard that would make someone feel less than others in the workplace. And here I want to note that many of these changes, especially regarding the harassment standard, bring the state law more in line with what the New York City human rights law, a local law that prohibits employment discrimination within the New York City limits, has already had in place for some time now. So it is a considerable expansion of the state law. However, if you are already operating in New York City, then it will just provide an additional avenue for claims on a broader standard than what is currently available under the state human rights law, but will not be entirely different from what the New York City human rights law currently has. For everyone else in upstate New York and outside of New York City limits, this is a very dramatic sea change in the standard for proving harassment. Just a couple more points on the law specifically. Failure to make a complaint is not determinative. This sort of attacks a long-standing defense that employers had, which basically said if you had a viable and effective complaint process and you investigated cases and handled them appropriately, then under certain circumstances at least, employees would need to show that they failed to avail themselves of those corrective measures before they then pursue a harassment complaint. Arguably, these amendments destroy that defense altogether. They specifically say that failure to make a complaint is not determinative. So at least in some cases, you won't be able to just say they never complained about harassment, therefore we're not liable. Arguably, you could show that under the circumstances, their failure to complain is somehow a relevant factor. But again, a significant erosion of defenses that employers have historically had against harassment cases. Employees also now no longer need to demonstrate the existence of an individual to whom the employee's treatment must be compared. In other words, they don't have to specifically say that another specific individual employee is treated better than me to show that they have been subjected to inferior terms, conditions, or privileges of employment. It's not completely a given that they had to make that showing before, but the new amendments just again are seeking to eliminate some of the possible defenses, in fact, most of the possible defenses that employers have historically had against harassment claims. What defense does the law leave employers? It now provides a specific affirmative defense, meaning the burden is on the employer to show that the harassing conduct does not rise above the level of what a reasonable victim of discrimination with the same protected characteristic would consider petty slights or trivial inconveniences. Hence the subtitle for today's webinar, that the laws are more than a petty slight or trivial inconvenience, what I think is true of the legislation generally. But this is a direct quote now from the proposed new statute that, again, the governor is expected to sign, and all of these components will take effect 60 days after signing. So we're looking at as early as September of this year for all of these new relaxed standards to go into effect. So I think it's going to be a pretty hard defense for employers to say that a reasonable victim of discrimination would consider something a petty slight or trivial inconvenience. Historically, harassment cases have relied on a reasonable person standard, and this is a deliberate relaxation even of that to focus on a reasonable victim. And it's fair to presume that a victim of particular discrimination would have a lower tolerance than a reasonable person who may not have been a victim, for example. So there are new penalties as well. Before I get there, I just want to summarize the previous slide. I'll even flip back to it. That on the whole, this is going to mean that it will be much easier for employees to successfully complain to, for example, the New York State Division of Human Rights about harassment. There's a real possibility that many employee side attorneys, plaintiffs' attorneys, will focus on this area to build up their practice, and I've already seen some evidence of that. Nothing against them. I think you should just take it as an indication, if you start to see it, of the relative ease by which it is expected that employees will make successful harassment claims. I think we can expect a greater number of settlements to arise, and my biggest fear is that we will see more cases where there's never been any mention of harassment internally because someone will eventually lose their job and then be upset and look for whatever they can do, and especially if they find information from some of the attorneys that would file these cases on their behalf and speak to them, then there may end up being lawsuits where there previously would not have been because there would not have been enough to meet the severe pervasive standard, but nonetheless there might be something that we can point to, that is, say the employee could point to say that they were treated worse than someone else because of a comment or a slight of some variety. Not a petty slight, of course, but nonetheless something slightly more slighting, I suppose. While I'm mentioning these practicalities, note that there are many new penalties. There are now punitive damages available. This is against private employers only, so if you're within a public entity, there would not be punitive damages available against a local government or school district or county or something like that. Notably, these punitive damages have no cap in the statute, which differs from federal discrimination laws, which have previously allowed punitive damages but are capped. For example, the maximum punitive damages under Title VII is $300,000. So there is theoretically now no cap, just what the jury decides to award and a judge doesn't deem to be too excessive. There will now be mandatory attorney's fees to prevailing plaintiffs. So previously in sexual harassment cases, it was possible for there to be attorney's fees awarded to prevailing plaintiffs, but it was discretionary. Now the statute reads that attorney's fees shall be awarded to a prevailing party. However, defendants can only, employers that is, can only recover attorney's fees if they can show that the case was frivolous. So again, really it's mandatory attorney's fees if the plaintiff wins, and highly unlikely that an employer could recover its attorney's fees. And frankly, even if you could show the case was frivolous, you might have a hard time collecting any attorney's fees from an employee plaintiff anyway. These penalties take effect again, or also 60 days after the bill is signed. A couple more components on the changes to the human rights law specifically, and we have some other topics to discuss. First, there is a new provision going in that says that the human rights law must be construed liberally to accomplish remedial purposes, even if similar federal laws have not been interpreted as broadly. So historically, the courts in New York have looked to how courts have interpreted the federal employment discrimination statutes to determine how to apply the New York State human rights law. This is a clarification, really a considerable expansion of a little bit of existing language in the human rights law that now says that the human rights law has to be interpreted liberally to accomplish remedial purposes, not to put any sort of political undertone on the word liberal here. The clear intent is that the law should be interpreted in favor of prohibiting employment discrimination, including harassment. And it's clear based on some of these amendments that the legislature intends there to be more protection under this state law than there is under the comparable federal employment discrimination laws. The amendments specifically add the statement that exceptions there's a typo there, and exemptions from the provisions of this article shall be construed narrowly in order to maximize deterrence of discriminatory conduct. So perhaps wherever I was saying earlier that arguably you could say this and maybe there's a defense that this other thing, you would be fighting against that provision where plaintiffs will be able to argue that no, there's really no defense because there's clearly not intended to be any exception or exemption from the provisions that are designed to find discriminatory conduct. The amendments say that this provision or these parameters are effective for new cases filed after the governor signs the bill. There might be some ambiguity there. Does the underlying conduct itself also have to occur after the law takes effect, or as long as the case was filed after it takes effect, the standard will now be applied to cases involving conduct that occurred in the past? Hopefully it's not that last part, but regardless, the new standard will take effect as quickly as possible once the governor signs. Okay, so that summarizes or goes through all of the specific changes to the New York human rights law, but there are several other amendments, some that the governor has signed, as I mentioned, and some that he has not yet signed that would also relate to the issue of employment discrimination. One of these has to do with non-disclosure, meaning confidentiality agreements. There were amendments to state law recently as a result of the Me Too movement that specifically prohibited confidentiality provisions for sexual harassment claims. The current legislation is now extending that to all employment discrimination claims. It doesn't actually limit itself to claims under the New York human rights law as well, although it specifically mentions that all such claims are included. So now employers cannot include confidentiality or non-disclosure provisions, whatever you want to call them, in an agreement that would prevent a person from disclosing facts and circumstances of a discrimination claim. There is an exception where, quote, confidentiality is the complainant's preference. This exception has been in place for the sexual harassment claims for a little while as well. But again, now any form of employment discrimination claim cannot be settled or waived in an agreement with a confidentiality provision preventing disclosure of facts and circumstances related to that claim unless you can prove that the confidentiality component was the complainant's preference. The other bullet point here, this now applies for any claim the factual foundation for which involves discrimination. It just is what I've already said. It covers any basis. Now, race, age, disability, etc., that someone might have a discrimination claim. Arguably, again, discrimination itself is a undefined term here, and, could be problematic in interpreting in some cases, but for the most part, we know what this covers. This requirement, again, is a 60-day after governor signs the bill effective date. Now I want to get to the confidentiality being the complainant's preference because there are many more parameters specified in figuring out what that means. So if you are in a situation where you are trying to settle or somehow resolve or have an employee or former employee waive a claim of employment discrimination of any kind, and you want to have some sort of confidentiality provision, you will have to ensure that it was the complainant's preference, and here is the way to do that. First, the employer will have to provide the terms of that provision in writing, in plain English, and in the complainant's primary language if that is something other than English. Once that is provided in writing, there's then a 21-day waiting period, and this is a non-waivable waiting period. So the complainant, the employee that is, can't say immediately or after a week or two, okay, I'm good, I will sign this, it's my preference. No, 21 days has to pass. Then the provision can be included in an agreement that might include other things, the term of settlement, etc., and it can be signed off on by the parties. Once it is signed off on, there is then another mandatory, this time 7-day revocation period before the agreement could become enforceable. So overall, from the day you decide you want to have a confidentiality provision, or even the employee requests having one, there is at least 28 days that has to elapse before that agreement could become enforceable. No one can waive or shorten that period. The 21 and 7-day periods may seem familiar to some of you who are familiar with employee releases, because there are similar waiting periods and revocation periods required to waive age discrimination claims under federal law, and those periods are often used generally for waivers of employment discrimination claims as well as other employment-related claims. One notable distinction again there is that 21-day waiting period is waivable by the employee and they could sign immediately. But again, that is not the case in this situation. I know this gets confusing. Just to clarify again, this is something that's currently in place for sexual harassment claims and settlements related to those. It is in the legislation that has been passed by the New York State legislature, but is awaiting signature from Governor Cuomo. He's likely to sign, and after he does, you would need to do this for all employment discrimination claims. So if you currently have severance agreements or settlement agreements or waiver and release agreements, whatever you might call them, that require confidentiality, that confidentiality provision is not going to be valid unless you go through this process. There is yet another component of the amendments on confidentiality agreements. This one specifically doesn't take effect until January 1st, 2020, apparently regardless of when the governor signs it. Obviously, it will never take effect if he happens to not sign it, but if he does sign it, it will take effect either January 1st, 2020, or when he signs it, although it's not reasonably possible that he would wait that long to sign it, or even could. If the governor does sign this, then beginning January 1st, 2020, any confidentiality agreement must specifically inform the complainant of their right, notwithstanding the agreement. In other words, even if they sign it and you go through that whole process, they will still be able to disclose facts related to the discrimination or alleged discrimination to law enforcement, the EEOC, the New York State Division of Human Rights, a local commission on human rights, for example, the New York City Human Rights Commission, and any attorney retained by the employee. So this would be a mandatory portion of any confidentiality agreement, even if you can go through all of that extensive procedure to demonstrate that the confidentiality agreement itself is the complainant's preference. Okay, here's another topic that we can probably get through relatively quickly for a couple of reasons. Arbitration, again, for sexual harassment claims, this has already been the law for a little while, that the New York State legislature, signed by the governor, had said that you could not have a mandatory arbitration provision that covers sexual harassment claims. The amendments now extend that from sexual harassment claims to all forms of discrimination claims. However, and the legislature knew this, that statute is of questionable validity given federal law that encourages the arbitration of disputes. In fact, recently, as in last week, when we're presenting this webinar, a federal judge struck down the existing law that prevented mandatory arbitration of New York sexual harassment claims. It's still possible there could be appeals and different courts could rule differently. However, it certainly seems reasonable that the Federal Arbitration Act does preempt New York state law in this respect. But once, again, the governor signs this new legislation, the law will say at least that employers cannot have mandatory arbitration provisions with respect to discrimination claims. Now, many of you have labor union and arbitration provisions in your collective bargaining agreements that cover many things, possibly including discrimination claims. And in the specifics, the outcome there could vary, but this is more principally aimed at employment agreements that have mandatory arbitration provisions, either with an individual employee who has an employment agreement or some form of contract or agreement that all employees of an organization have to sign. That is really the evil, quote unquote, that this type of law is going after, on the theory that employees forced to arbitration over these types of claims, which might often include confidentiality provisions, do not have as much recourse to redress their claims as someone who has the right to go to court. All right, so like I said, there's a lot here. Now we're turning back to the sexual harassment policy and training requirements that took effect in New York last year. As I mentioned, the first deadline for completion of annual sexual harassment training is October 9th, which is probably close to when many of these amendments will take effect, with the 60-day period after the governor signs, assuming he signs sometime in the next month. But of course, it wouldn't have been enough just to let that process play itself out. We have to amend it yet again before the first deadline even comes to pass. So now there's a specific requirement that upon hiring and at each annual sexual harassment training, every employer must provide written notice containing its sexual harassment prevention policy and the information presented at the training program. I don't know how big of a change it really is regarding the policy itself. I think best practice would have been anyway to provide a copy of your policy at the training, although that wasn't specifically required. Usually your training is discussing components of the policy, so it makes sense to provide it at that point in time. What this reference to the information presented at the training program means is a little bit less certain. Does that mean you have to provide a copy of, for example, slides or outlines of the training session, or does it mean something different or more? So again, that's a little unclear. Maybe we'll get some guidance from the Department of Labor clarifying that. But one way or the other, probably the bigger burden for some employers anyway is a new requirement that this, both the written policy and this information, might have to be provided in English, in languages other than English. I'm going to get to that in a moment. Just know that all of these requirements apparently will become effective immediately upon the governor's signing. So if you have a sexual harassment training scheduled sometime soon, you probably need to pay attention to when and whether the governor signs this legislation, because you might suddenly have a new obligation that you will have very little time to deal with. So here's more on the language requirement. The Department of Labor, the New York Department of Labor, is expected to prepare model policy and training program documents in multiple languages. The Commissioner of Labor gets to determine which languages those will be. But if there becomes a Department of Labor template available in any particular employee's primary language, then their employer must provide the sexual harassment policy and training materials in that language and English as well. There are currently training videos available through the state's sexual harassment website with slides and subtitles in the languages on this slide. So Bengali, Chinese, Haitian Creole, Korean, Italian, Polish, Russian, and Spanish. Now, these videos are someone at the Department of Labor speaking on camera and alternating with PowerPoint slide. The person speaking is speaking in English, and there are subtitles in these various languages. When you get to the actual slides in the video, they are written out in the respective languages. There, to my knowledge and based on my review, do not appear to be model policies in all of these languages at this point. I couldn't find anything other than English, although perhaps they're out there somewhere. But it is likely that the Department of Labor will get those produced relatively soon. And this could be one issue that would slow down the governor signing this legislation altogether. Like I said, it does appear that these requirements, including the language requirement, become effective immediately once the governor signs. So it's not out of the realm of possibility that the governor's office is coordinating with the Department of Labor to allow it some time to provide these model policies and training programs in additional languages so that it's possible for this provision to mean something. Of course, the other possibility is they will just pass sign the legislation, and there won't actually be an obligation to provide anything in additional languages yet, because the Department of Labor hasn't yet provided model policies in those languages. One big gap in this requirement, of course, is that employers are not required to use the state's model policies and training programs. I would say that it's actually better that employers not use them, or at least adapt them to their own purposes. But once there is a model policy or training program in place in a particular language, and you have an employee who speaks that language as their primary language, then you will have to provide them the policy and training in that language, meaning either you use the state's model or you will have to translate your own policy and training into another language, which of course could be costly, or at least time consuming and logistically complicated. There is further discussion in the amendments that says the Department of Labor must reevaluate and update the model policies and training programs every 4 years, beginning in 2022. I think realistically, they're going to have to do that right now. There are changes that will be obsolete before 2022. One thing I didn't put in the slide, but as another component of the human rights law amendment, is that now for sexual harassment claims only, employees have up to 3 years to file them with the New York State Division of Human Rights, where currently it's only 1 year. For all other employment discrimination cases, they'll still only have 1 year to file with the Division of Human Rights. but for sexual harassment, it will be 3 years. That is something that's currently addressed in the model policy and a requirement that be addressed in your sexual harassment policy. So that is something that once the law is signed will need to be changed, although technically it doesn't take effect immediately. So that's another complication. But if nothing else, some of the language in the sexual harassment policy still presumes a higher standard than what it will now be the case due to the amendments. So you should consider that. And certainly the training should go to a different level than what training has gone to before, because now there is essentially no tolerance. I mean, there was probably never supposed to be any tolerance for any form of harassment, sexual harassment or otherwise, but now the employer's legal liability will take effect on potentially the first minor instance of some form of unwelcome conduct. So the training becomes more important than ever. How effective you can make your training is always a question, but the reality is you should give more consideration to it under these new laws than you did now before, because you are more likely to face harassment claims and more likely for those to be successful with potentially significantly higher penalties, litigation costs, etc. I think that summarizes that slide, which gets us to our last topic, and then I will take questions. Again, if you have questions, you can go ahead and start typing those in, but I will ask for questions. Again, I should mention that all of these slides will be made available to you as well. I will provide a link as soon as we get through the materials so that you can download the slides. You will also get a follow-up email if you're registered for this webinar that will give you the link to the slides. So pay equity is a topic that has been developing as well at the local level. Some counties have passed salary ban legislation or ordinances, but now we have such laws at the state level in New York. New York has long had an equal pay law. Get back to the salary history ban in a second, but it's important to start here. There's been an equal pay law for a while in New York, as there is one at the federal level. But historically, these laws have prohibited pay disparity only based on sex, principally to say that men shouldn't be paid more than women for the same work. But now the equal pay provisions of the New York labor law will apply to all protected characteristics under the New York human rights law. The law itself is not in the human rights law, but it does reference all of those characteristics like race and familial status and marital status, religion, etc., that are found in the human rights law. In addition to extending the scope of protected characteristics, we now have broader protection because the standard has changed from equal work to substantially similar work. So before, an employer could say we're paying this person more because they're doing a different job, perhaps a slightly different job, but a different job. Now, if the employee can show that the job is substantially similar, then there should not be a pay disparity based on any of the protected characteristics. And an employee probably could have already made discrimination claims based on pay under the human rights law, but it's important to note that the equal pay law does provide additional remedies and a longer statute of limitations. While I kind of mentioned you can file discrimination claims for up to 1 year with the New York Division of Human Rights, you can file human rights law claims directly in court for up to 3 years. This law, the equal pay law in New York is in a portion of the labor law related to wage payments that has a 6-year statute of limitations. So it gives employees longer time periods as well as additional remedies, potentially including liquidated damages. So if they show I should have made a certain amount of money that someone in a different protected characteristic made, they might not only recover that amount, but they could recover an additional equal amount for liquidated damages, or if there's found to be a willful violation, they could get multiples more in the form of liquidated damages. This has been signed off on last week by Governor Cuomo and will take effect October 8th, 2019. Companies need to be very careful about their pay practices at this point. Certainly wouldn't wait until October 18th to assume that this is the standard. Anything you do between now and then will come back to haunt you later. The reality is defending these types of claims becomes a very statistical endeavor with expert witnesses in some cases, because you're trying to isolate variables that aren't a protected characteristic and say that is really why there is discrepancy in the pay. The law itself does allow for there to be differences in pay. It's not to say everyone in the same job has to have the same pay, but it has to be a difference that is not connected to the protected category. So, for example, if it's based on a seniority system, a merit system, or a system measuring earnings by quantity or quality of production, then there's a viable difference there. Otherwise, there has to be some other bona fide factor other than the protected characteristic. But one factor can arguably correlate to another factor, and it can quickly become complex litigation where plaintiffs can recover their attorney's fees if they ultimately prevail. So complex litigation can mean that an employer is paying 2 sets of lawyers to resolve it. Also aimed at equity, as I mentioned, pay equity, as I mentioned, is the salary history ban that we started to see at the local levels, downstate, and now have it statewide. The law will prohibit employers from inquiring about applicants' wage or salary history. So if you previously made the simple inquiry and interview of what's your current salary, that will no longer be permissible. You can also not contact employers of applicants to try to otherwise find out what they're currently making. And then even if you do somehow get the information, for example, because the applicant voluntarily disclosed it, you are prohibited from using the information in making a hiring decision or in determining wages. So seems like you're better off not having the information, because once you have it, how are you going to not use it? Or even if you manage to not use it, how are you going to prove that you didn't use it? Interestingly, the law also applies even for current employees. So you cannot consider wage or salary history in making promotion decisions or in determining how much to pay someone once they're promoted. Now, I think that's probably a little bit impossible. If you know how much someone's making now and you're promoting them, you're likely going to be paying them more, and you're going to know you're paying them more. But again, the law is intending to get at paying someone what the job is worth more than, I would even go so far as to say what that person would be willing to do the job for, on the theory that that latter criteria is likely to have a discriminatory impact on certain groups. There is an exception if the employee discloses their salary in trying to negotiate a higher wage. So if you've offered a salary to an applicant, for example, and they say, well, I'm making this much now, so I need at least this other amount, at that point you can consider the information. You may also be able to confirm the information if you need to without violating the law. This has been signed again, so it is effective January 6th, 2020. But as I mentioned on the previous slide, the pay equity laws will take effect October 8th. So I would not be waiting until January 6th to stop asking for this information, because it could be used against you, even though technically legal in and of itself, in a claim under the equal pay statute. Okay, so that is a lot of information. Some of it about laws in effect now, the rest of it about laws that are almost certainly going to take effect in the next 6 months or so. I will take questions now. I see we already have one. In just a moment, I will put up the link to the slides for those of you that want that. We are just about at our hour, but as I said, I will continue to stay around to answer questions as they continue to come in. So start getting those in. Let me put up the slides. Okay, so you should have something that will let you click to download the slides for your reference later. Couple good questions so far. Keep them coming. The one I just saw, will you be sending out alerts as laws are signed or not signed? Yes, we'll certainly do our best. I just wrote up something on the salary history ban law yesterday. That's published on our blog at hortonpllc.com. If you are registered for this, then you will be on our email newsletter that we send out monthly. We normally only send it out monthly, but that will include our articles about all the updates as they take effect, or we have some new information about them. If something suddenly takes effect and it's so critical that we think you need to know about it, we will try to send that out faster, but we don't want to annoy you with too many emails. But if you ever have any questions, or you're starting to do something and you're wondering whether that law is in effect yet, certainly follow up and let me know. My contact information is all on this screen. Another question that came in just a moment ago, can you ask for salary expectations? Yes, as far as I know, you should be able to do that. The law doesn't seem to specifically prohibit that. Realistically, if you ask for salary expectations, then there's the risk that the person is going to tell you what they are making now. I think that's probably not a violation. You probably still haven't inquired as to their current salary by asking that. But again, once you know it, you are then bound to not rely on that information, and how you can not rely on it, or how you can prove that you didn't rely on it, is another question. So it'll be tricky, asking questions like, what is your salary requirement? Raises the similar type of issue, but I guess you'll have to play around a little bit with what the best way of determining that will be. I mean, honestly, the way the law is written, you really should, it almost begs you to have a mathematical chart that says, you factor in this person's relevant experience and what the job entails and whatever, all kinds of bona fide factors other than protected characteristics, and then it spits out a number. That's not how the world usually works, at least if you're not a very large corporation. But it is burdensome, and you will just have to be careful. So I don't see any more questions yet, but we still have a large number of you hanging around. So Go ahead and enter more questions if you have them. I'll pause just a moment. So I am checking on a nearly daily basis to see when Governor Cuomo acts on this legislation. There is the possibility of him trying to coordinate it with some other event. He signed the pay equity legislation last week in connection with the U.S. women's soccer team's parade in New York City, because they famously have a fight over pay equity ongoing. So there could be something like that he's building up to, or perhaps he's actually considering some of the impact on businesses and trying to figure out how to weigh that and implement it in a reasonable manner. But I'm not too optimistic that there will be any way to stop these amendments from taking effect. And I do think it will have a significant impact. There is the undercurrent of the inconsistency between some of the requirements on the sexual harassment training and the expansion of laws related to all other forms of harassment. So I would also note that you probably should take very seriously training on other protected characteristics and not just be led down the path of focusing on sexual harassment, because just as likely that you will be facing claims of harassment on other bases, and your best defense and perhaps only realistic to defense to harassment claims going forward will be ensuring that nothing that looks like harassment takes place in the first instance. This may change your disciplinary standards related to, sort of interpersonal conduct in the workplace, behavior that probably wouldn't have led to liability before, and hence might have had a certain response from an organization, may be more likely to, will be more likely in some cases to be grounds for successful harassment claims now, and hence your organization might have to raise its disciplinary bar. Basically, you have to give stronger consideration to removing people from the workplace if they show that they are likely to cause trouble that could produce harassment claims. Here's a good question. Do you expect that any of these amendments will affect the way that state and federal claims interact procedurally? Yes. There is something in the law that I didn't put into this presentation that actually changes procedural ability to have claims simultaneously pending in different venues, but then you get into other estoppel types of issues. So I don't want to get into that level of complexity, but what's really going to happen is employers are likely to see fewer claims getting into federal court, because plaintiffs' attorneys are going to be more than happy to go into state court with harassment cases or discrimination cases now that attorneys' fees and punitive damages are available. So it used to be that attorneys' fees were available under the federal laws but not the state laws, which would result in cases getting in federal court, which different people have their perspective on that. But now it is probably more likely that plaintiffs' attorneys will want these cases in state court. I will just further add that the fact that I'm saying that plaintiffs' attorneys will be more likely to want these cases in state court might well mean that as employers, you should not see that as a good thing. Another question. If your company has already released a new version of the training, will they have to revise it again? I'm going to answer the question yes. Whether you're going to have to officially do it to comply with the sexual harassment training requirements from the state, less certain. Most of the training is probably still going to be valid, and it might meet the minimum requirements that the state sets forth. From my standpoint, though, you should be taking training that much more seriously and emphasizing it that much more than you already were with the lower standard. I think you need to let your employees understand what the standard is, or especially supervisors need to understand that the standard is low, especially ones who've had experience with harassment like situations in the past. They need to know that expectations may be different and even more um, imperative than they were in the past. The training will certainly have to change over time to meet whatever the Department of Labor is going to say is required, as is expected to have to review every 4 years its templates and requirements. But even before that, you will at least have to meet the written notice requirement, whatever that exactly means. Hopefully there will be some guidance from the Department of Labor, and you will have to deal with the primary language requirement. As far as the question of if you've already done your annual training for this year, you probably don't have to do new annual training before October 9th. But once your next year training comes, then you would probably be expected to have compliant training if there are new guidelines from the Department of Labor. There's a question. I have an employee whose primary language is Arabic. What guidance would you suggest? Well, let me give you the most practical guidance is that you want to make sure that your training is effective as to all of your employees. Now, I suppose you could be convinced that any particular employee is highly unlikely to engage in harassment, and or if they have any supervisory type responsibilities, knows what to do if they hear of any harassment. The other possibility is you have this employee who speaks English fluently and won't have any trouble understanding your English policy or training. But beyond that, and until the state has model policies and trainings in other languages, you may not technically have to give the training in that particular language. But, again, if that leaves you in a situation where you're facing a harassment claim and you can't prove that the person actually understood your training, although that might not matter much under the new standards, or more importantly, if having provided the training in Arabic would have helped prevent harassment from taking place in the first place or escalating to a higher level in the first place, then whatever it would have cost you to arrange to provide the policy and training in that language probably would more than pay for itself. So again, that's what I'm concerned about with the sexual harassment training requirements is employers checking the box where the penalty for not providing the training basically seems to be minimal, whereas on the other hand the penalty for allowing harassment to occur can be quite significant. So I would just encourage everyone to think of the training not as a way of meeting the state requirement, but ideally as a way of at least reducing the risk of harassment taking place in your workplace. I appreciate all the good questions. There's still a number of you on here. If there are more questions, I'll just pause for a few more seconds to see if you have a big question you're typing up, go ahead and enter half of it so I know to stay on. Do want to thank all of you for joining today and spending the time to get updated on what I really do think is a critically important topic for New York employers. No one wants harassment to occur in the first place, but these standards are going to be a game changer from the liability standpoint and from a practical standpoint, because you want to stay ahead of the law and not be on the wrong side of it. If you do have any follow-up questions, again, you have all of my contact information. You have these slides, and look for additional information on these amendments and potentially additional issues as they develop in the future. So I don't see any more questions. I will go ahead and wrap up at this time. Thanks again, and hope you enjoy the rest of your day.